Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I am here with my co-host, and today we are discussing the Administrative Procedure Act and how it provides a legal right to force USCIS to decide your case.
In Episode 1, we introduced the concept of mandamus and mentioned that immigration delay lawsuits typically include claims under both the Mandamus Act and the Administrative Procedure Act. Today we are going to examine the Administrative Procedure Act in depth.
What is the Administrative Procedure Act?
The Administrative Procedure Act, commonly called the APA, is a federal statute enacted in 1946. It establishes the fundamental rules for how federal administrative agencies must conduct their business. This includes rulemaking procedures, adjudication procedures, and judicial review of agency actions.
Why was the APA enacted?
By the mid-20th century, the federal government had grown significantly. There were dozens of agencies making decisions that affected millions of Americans. Congress recognized that there needed to be uniform standards governing how these agencies operated and how citizens could challenge agency actions in court.
So the APA was designed to provide accountability.
Exactly. The APA ensures that agencies follow consistent procedures, that their decisions can be reviewed by courts, and that people affected by agency action have legal recourse when agencies fail to act properly.
How does this apply to immigration cases?
USCIS is a federal administrative agency. When someone files an immigration application, USCIS is required to follow certain procedures in processing that application. The APA governs those procedures and provides remedies when the agency fails to comply.
What specific provisions of the APA are relevant to immigration delays?
Two provisions are central. The first is Section 555B of the APA. This section states that within a reasonable time, each agency shall proceed to conclude a matter presented to it.
That language is direct.
It is a statutory command. When someone files an immigration application, they have presented a matter to the agency. The APA requires the agency to conclude that matter, meaning to issue a decision, within a reasonable time.
What is the second key provision?
Section 706 of the APA, which governs judicial review. Specifically, Section 706(1) authorizes courts to compel agency action unlawfully withheld or unreasonably delayed.
So the APA not only requires agencies to act within a reasonable time, it also gives courts the power to enforce that requirement.
Correct. When an agency unreasonably delays action on an immigration application, the applicant can go to federal court and invoke Section 706(1) to compel the agency to act.
How does an APA claim differ from a mandamus claim?
The two remedies are related, but have different legal foundations. Mandamus, as we discussed in Episode 1, derives from the Mandamus Act at 28 U.S.C. Section 1361. It requires the plaintiff to show a clear right to relief, a clear non-discretionary duty, and no other adequate remedy.
And the APA has its own framework.
Yes, the APA provides an independent statutory basis for judicial review of agency action or inaction. Section 706 sub 1 specifically addresses the situation where an agency has failed to act. The plaintiff must show that the agency action was unlawfully withheld or that the delay is unreasonable.
Are the standards for evaluating delay the same under both statutes?
Courts generally apply the same TRAC factors when evaluating delay claims under either the Mandamus Act or the APA. The 6-factor test from the TRAC case has become the standard framework for assessing whether agency delay is unreasonable, regardless of which statute is invoked.
Why do plaintiffs typically bring claims under both statutes?
There are strategic and practical reasons. First, the two statutes provide complementary legal theories. If a court finds that one claim has a weakness, the other claim may still succeed.
It provides redundancy.
Yes. Second, different courts may have different views on the scope of mandamus jurisdiction versus APA jurisdiction. By pleading both, the plaintiff ensures coverage regardless of how the court interprets the jurisdictional question.
Are there situations where one statute might apply but not the other?
There can be. Some courts have held that mandamus requires a more demanding showing than an APA claim. The traditional mandamus elements, particularly the requirement of a clear, non-discretionary duty, can be interpreted strictly. The APA's language about agency action unreasonably delayed may be broader in some circumstances.
So the APA can sometimes provide relief, even if the mandamus claim faces obstacles.
That is one reason why experienced attorneys plead both claims. The goal is to present the strongest possible case for compelling the agency to act.